So it'd be a motion to unseal. And I'd feel bullish on this as well. Although, frankly, we see this all the time, and it's a good topic to talk about because warrant materials seem to be sealed presumptively, and I don't think the law is set up that way. They are judicial records once it's returned to the court, and they're subject to the right of access. And so we constantly have this kind of battle in newsworthy investigations where search warrants are returned and even the suspect is indicted. And at that point, we think there's a right of access to these materials, so you have to go to court and move to unseal. But unfortunately, they are sealed a lot of times, and so it requires putting resources into getting a lawyer to show up in court, to make a motion, to make an argument. But I do think in this case, there'd be a good argument to unseal these materials because, again, you have this really great public interest that exists with a gubernatorial candidate. And I also think some of the risks that, a compelling interest that might keep these documents sealed don't really exist here. It's not a situation where there's a suspect who's not yet known. I mean, the governor, everyone knows it's the governor. These materials of these events have occurred. So I don't think there's a risk that documents get destroyed or that some unknown suspect is identified and given an opportunity to flee, things like that. So short answer is a motion to unseal, and I think there's a good argument for it.
Yeah, and I think on this, I would feel much better, and we would be more aggressive on it. I think that's right, at least under common law, that search warrants are judicial documents, but then you need to look at the federal law enforcement interests, you need to look at privacy interests, and if we're talking about financial documents, if we're talking about agreements among a number of folks, first, there are people involved whose identities may not be known. We're going to be concerned if we are at the very beginning of our investigation, which seems to be the facts here. This is not, someone hasn't been charged. We're not towards the end of a case. We're going to be concerned that if certain information is out in the public domain, it may alter the way that witnesses respond to questions. It may lead to the destruction of evidence. There are all sorts of law enforcement concerns that we're going to have about both what's in our search warrant itself and the application, and then what we obtain as a result of it. And then I think in the hypothetical, it's also about subpoenaed documents, which of course are not judicial documents. We're talking about a grand jury investigation, so that's going to have a whole other set of protections there.
Well, I don't think they should be presumptively sealed.
Yeah, I know, but I'm saying, what do you typically find that you're saying are often?
Well, I think it's search warrants. So the materials that come back in inventory of the documents that were
search warrant returns.
Yes, yes.
Well, Judge Stein, how do you plead? Is there an assumption for sealing that you think that courts typically exercise in state matters when there is a search warrant that's executed?
Well, I think that the courts also have to look to protecting the process and the rights of the accused to a fair process. And so, and if it's going, and that also is related to the or opposed by the prosecutor's interest in investigating the crime or the alleged crime, so you have to be somewhat protective, and you have to look at what the opposing balance it with the opposing need to know and how strong that is, and you have to look at what the stage of the proceedings is as well. So if it's going to affect the investigation, if it's going to affect ultimately the accused's right to a fair trial, then some protection of those documents needs to be in place.
Well, as I understand it, there was a grand jury subpoena served. And under Rule 6E of the Federal Rules of Criminal Procedure, I think it would be very difficult to get access to the subpoena or the materials obtained through the subpoena. With respect to, but you know, I'd love to hear argument from counsel, and you'd always hear argument from counsel. And with respect to the search warrant, the documents obtained pursuant to the search warrant are not in the court's custody. They're in the custody of the U.S. Attorney's Office. They're not judicial documents. So I think what we're talking about is the search warrant itself, a supporting affidavit, which may have a lot of confidential information in it, depending on what law enforcement used in order to create the probable cause to support the search warrant. And then the return on the search warrant, which my co-panelists mentioned. And I think typically, first of all, return isn't necessarily very revealing of much. I guess you learned that there was a search because the camera crews were outside as the FBI was carrying the boxes out of the governor's mansion or office or whatever. It wasn't middle of the night search. So the return that listed 6 boxes of documents and 3 hard drives is probably not very interesting. So you know the search took place. So I think there's not going to be much discovery, I expect, actually, that the press would be able to get out of either of those law enforcement actions, either the grand jury subpoena or the search.
I don't even know whether certainly in federal court, I don't even know whether I would have to get into the courthouse door because I've got this very powerful assistant U.S. attorney on my side. I've got Judge Cote, who probably has not very often released any grand jury material. And so it's pretty basic that that material is going to be highly secret. I think that's one of the most powerful protections in our criminal justice system is the protection of grand jury material to protect both the innocent and also to protect the government's law enforcement function. So on the criminal side, I'm pretty comfortable. Where I've got the problem here is on the civil side, the matrimonial litigation. And there, unfortunately, it really does seem to be a very common experience that people who are really have no issue in a litigation get sort of sucked into it. Somebody once said, when the elephants fight, the grass gets trampled. And my clients are grass in this situation. So what am I going to do? I think I would go in and ask for some kind of a protective order. I probably would start by even trying to negotiate with the parties here and see if they would give me a protective order. If they won't give me a protective order, I think one of my stronger arguments to Judge Stein is that the wife is playing games here. She is trying to really make a big circus here for reasons that have already been discussed that really have relatively little to do with the matrimonial action. And my clients are being very badly injured, and so that if the parties won't agree to a protective order, I would ask the court to impose a protective order. And I think I would have, I'm sorry to miss your question, I think I would have decent standing on that because I am being injured, and I think that's sort of a discretionary kind of thing, but the judge could either let me in or not let me in, but I think my interests are pretty obvious.
Well, under the hypothetical, there are no federal proceedings really ongoing. And, you know, the First Amendment interests basically impact federal proceedings in terms of access to the courtroom, to watch what's happening in the courtroom as it's ongoing, and 2, for access of documents that are filed with the court by the parties. We term them judicial documents that are used in judicial decision-making. None of that is happening when parties exchange discovery material between each other. And usually the exchange of discovery material is protected through what we referred to here as a protective order, so that the parties freely exchange documents knowing that they only risk becoming judicial documents if they're filed with the court. If they're filed with the court to support a motion or in connection with a trial or other proceeding, and by the way, I expect there's been a motion by now to adjourn the matrimonial proceeding. Why the matrimonial proceeding is going on before the election, I don't know. Anyway, so, but if we assume that the documents have come to the court as support for a motion of some sort, and a third party comes in and wants access to those, we are going to have to decide whether or not that third party's privacy interests are affected. And that's a general, broad rule, and it seems that would be easily met in this circumstance, that the financial records under the hypothetical that are being used to support the motion of some proceeding, which the hypothetical doesn't yet address, Mr. Wall would be able to make his motion, and that would be considered by the court in how much of the documents to redact. And usually you want to protect non-parties' privacy interests. That's a strong interest. Anyway, it's without more of a setting for the litigation before me, I think that's probably all I can say.